Hello everyone, thank you for joining us today, and thank you my MCLE for having us. By the way, you can contact us at the end of the program or throughout the program. We do have some swag. We have swag about our hospitality expertise and our credentials, and so at the conclusion of the presentation, feel free to contact us. My name is Mark Adams, and I'm here with my partner, Jim Butler. Jim Butler is probably the more renowned hospitality lawyers in the United States, probably the world. I am a commercial business litigation trial lawyer. Probably 70% of my work is specifically in the hotel arena. Jim, can you tell us what is our client profile?
Well, thanks, Mark. It's particularly important being here today discussing a panel like junk fees. I've been following Google search topics on this, on junk fees or resort fees for more than 15 years. And recently, if you Google junk fee lawyer, you get plaintiffs' lawyers who are dragging for people who want to sue restaurants, hotels, or anybody that has a junk fee. We are not junk fee lawyers in that sense. We're hospitality lawyers. We represent the developers, owners, managers, operators of hotels, restaurants, sports facilities, mixed-use real estate, the businesses themselves. We help them in litigation, as you know, defending their rights, helping them enforce their rights under various contracts, management agreements, franchise agreements, joint venture arrangements, litigation that comes up in bankruptcy or other things. And transactionally, we help them buy, sell, build, and refinance their properties, hotels, restaurants, whatever there are. So please think of us as hospitality lawyers who follow the issues that are important to our clients, the businesses in this area, not as the people who attack the hospitality industry, whether it's on junk fees or ADA or any other kind of matter.
So why are we here today?
Well, that's a great question. We're here today to talk about two main proposals. One is, can we get the next slide, please? One is at the national level, the FTC rule banning drip pricing, and that has probably been around the longest time. The FTC has been on top of this topic since at least 2012, when they published a definitive study about drip pricing and determined that it was an unfair means of competition and a deceptive practice. Very well documented. It's really part of the academic background of this whole subject. But that 2012 study was only about hotel resort fees, destination fees, hotel hidden fees. It did not go to any other industry. And then in 2017, the FTC came out with a proposed rule that would ban drip pricing for all industries, much like the current pending proposal that was issued last November 8, 2023, and which has had hearings most recently in April of this year. We'll talk about that more later. That, in a sense, has become the model of the regulation that's been adopted by California, many other states, some of the federal regulation. It really is well thought out. The 66 pages in that proposed rule are really the go-to reference book on the specifics of the kind of harm that drip pricing does to both the competitive process and to consumers in misleading them. But that still has not passed, so it's in the proposed column. Similarly, in the proposed column is a national law which would ban drip pricing, ban hidden fees for hotels, motels, short-term lodging, essentially anything of 30 days or less. It really tracks the FTC wording about drip pricing, but it applies only to hotels. That legislation was passed overwhelmingly by the House of Representatives. It has had no action since that passage in June. There is a very similar Senate bill that could either be amended to conform to the House bill, and it could be law very quickly, or the Senate could adopt the House bill, or Congress may fail to take action because they're distracted. We don't know. You stay tuned.
And so what's happening in California?
Well, California has had a lot of action. Most of it started last fall. Laws that were enacted in November of 2023. There were, some people know them by the bills. There was SB 478 and AB, referencing the Assembly Bill 537. SB 478 amended and really created California Civil Code Section 1770. That's the first law on the slide. You're going to see a lot of that because that's where most of the action is in the California junk fee laws. You'll see that CC, California Civil Code Section 1770. That also, by the way, is right in the middle of something called the Consumer Legal Remedies Act, CLRA. Those letters, that acronym, is used to refer to this whole set of provisions that provides consumer protection in the California Civil Code. The other section we're going to talk about today is Business and Professions Code 17586.6. That section was created by Assemblyman Mark Berman, and it's because he had a bad stay at a hotel in California. He checked out, they hit him with a mandatory resort fee, and the rest is law. It's been passed in California. But by the way, we're going to see soon, both of these laws are having an outsized effect because they apply not just to hotels in California, but to any offer, display, sale that is made to California citizens. So if you're on the internet or doing a radio or TV show or doing mass mailers or going in magazines, you're probably making offers to California residents, and you're triggering these laws. That's going to be troublesome for some people.
But these proposals have been around for a while. Well, why now?
Great question. Well, many of our clients started last year when the proposals were first passed into law and signed by the governor, creating the two major changes in 1770 and 17586. And that's what well-prepared people tend to do. But so that's some reason. They just became effective July 1. I guess the people who wait and want to see if there are changes can wait. But it's gotten a lot of attention, I think, particularly with operations that are out of state and really thought, this isn't going to apply to me, and suddenly are beginning to realize it does. They're seeing all the major hotel chains, Hilton, Marriott, change their ads. They're seeing cruise lines change their ads, and the ads are being designed to conform with the California law. So a lot of people are going, oh my goodness, they're just realizing what's happening. And the last factor is we had a crazy wild dash in June, the so-called restaurant exemption. The original California law, 1770, that we're going to be examining in detail, that was passed by SB 478, prohibited hidden prices from any business, was not limited in any way. The restaurant industry and Unite Here, one of the powerful unions in California, lobbied very hard, and they've made major contributions to all the California politicians, from city government to county to state, right on up to the governor's office. They are among the top political contributors. They basically called in the new bill, and they said, we want an exemption for restaurants from this hidden fee legislation. And they got it. On June 7, remember, the bill was going into effect for July 1. People had already prepared how to comply with it. July 1, weeks away. And on June 7, Senator Dodd introduced the exemption for restaurants that we're going to look at in detail. A little bit of a misnomer, because we call it the restaurant exemption, but it's considerably broader. It includes restaurants, bars, groceries, food services, and certain other providers of food, if they meet certain conditions. But that has thrown a wrench into the works. It was signed 2 days before the July 1 effective date of the other junk fee laws. So 48 hours before the laws went into effect. It is, to put it kindly, not well drafted. It reflects the fact that it was emergency legislation. It was rushed through in, it's got to be near record time, 3 weeks. They used extraordinary procedures, a gut and amend process of an existing bill that had to do with gambling commissioners, and that's the only way they could get it introduced and signed by the governor so quickly. So there are a lot of, I think, surprises waiting that are going to be a problem for people trying to do business.
So let's talk about California Civil Code 1770.
Great. Can we get that slide, please? I want to set the context of, we're going to focus on 29A and D that you see down at the bottom of this slide. Don't look at it now. Just remember, this is item 29 that's been added to section 770 little a. And little a, let's look at it together, talks about the unfair methods of competition and unfair or deceptive acts or practices listed in this subdivision. So that refers to the 29 numbered paragraphs that follow, the acts and practices listed in this subdivision. What acts and practices? Let's read it together. It's by any person in a transaction intended to result or that results in the sale of goods or services to any consumer. Okay, so these are just consumer transactions. They are not commercial transactions. And this is very broad. It's any kind of communication, right, that happens with them. So they're declared to be unlawful. The consequence of that is that there are many other provisions in the California legal structure, in the California Civil Code and elsewhere, Business and Professions Code, that provide if you do false advertising or have deceptive business practices, there are various lawsuits and damages and attorney's fees and injunctions and so forth that are the remedies for that. But, and again, I'm going to spend a little time just helping you see how the new section we're going to examine in detail fits into this. It is yet one more class. It's item 29 of these unlawful, deceptive, misleading practices. So let's look at the first few. Number one, passing off goods or services as those of another. Well, I mean, it's pretty simple. This is the sale, selling purses as they're Gucci or Prada when they aren't, when they're made in Mexico and they're counterfeits. That violates other laws too, the copyright laws and certain other laws, but it's a violation of subsection 1 of 1770A. Selling Rolex watches, those ones you see on street fairs, and they're going for $75, not $10,000. They probably quit working in a week or two also. But those would be a violation of Civil Code Section 1770 a, number 1. Number 2, misrepresenting the source, the sponsorship or certification of goods and services. We've been approved by the USA Athletic Committee. This is what John Wayne used to use. This meets USDA standard. Any kind of misleading reference, that something that is not true, that goes to the source, approval, or certification. And it goes on, misrepresenting affiliation and sponsorship, various items. We don't list it here, but probably one of the most common is number 9, and that's the basic bait and switch. It's called advertising goods or services with intent not to sell them as advertised. And Mark, as you know, we have seen a number of lawsuits filed in the last few weeks, in June, before this law became effective, that were not filed under the new junk fee law, but they were filed under bait and switch. The whole idea is, you told me it was a $10 hamburger, and now that I'm going to check out, you tell me it's a $13 hamburger because there's a $20 service fee that I have to pay. This isn't a voluntary tip. And there's a 10% fee I have to pay that's a San Francisco healthy fee, and one of your favorite restaurants got sued for that as well, as I recall. Okay, well, you get the idea of these 29 now items that are listed in Civil Code Section 1770 a 29.
So let me pause there for a second. So under 1770A, previously, before July 1, there were 28 items. And then on July 1, number 29 came into effect. Can you tell us about it?
Exactly. Well, 29 is where all the action is. This is SB 478, and if you look at 29, it has, of course, more subdivisions. If this could be properly indented, you'd be halfway across the page if each subdivision and subparagraph and subparagraph were indented. And you need to understand that we're now going into section 29 of it, and 29A. 29A is the prohibition on drip pricing. Let's look at it together, as this is going to affect everything else. This was originally 478, and it did not have the restaurant exception, which is now in D. We've just place marked big letter D and called it the restaurant exception down there. So A prohibits advertising, displaying, or offering a price. Now let's just stop there. It is the advertising, displaying, or offering of a price for a good or service. That does not include all mandatory fees or charges. And there's an exception other than taxes or reasonable and actual delivery. So you can't charge handling charges. Those handling charges are a junk fee. You can charge the actual and reasonable delivery fees, and those do not have to be disclosed. They are not a mandatory fee. But other than that, and until June 29, when the restaurant exception went through, that was the ban. in California. It is the first comprehensive ban of junk fees that has been adopted at state or federal level.
Nationwide.
Nationwide, that's right. The feds started it. The FTC rule started this with the rule we're going to look at the end.
Just the proposed rule.
Correct, and that's the issue. That was the model. The language was borrowed. There are extensive citations to all of the research in the FTC's rule, justifying it and finding the need and saying why it is a misrepresentation within the meaning of this provision of the code. But it was really a landmark. It was the first law adopted and put into effect on July 1 in the United States at state or federal level. I mean, that's really what the law is. It's a transparency law. I think we'll talk later about how some people, particularly to get the restaurant exception, just plainly misstated the situation. They said they couldn't charge amounts to pay their workers. They couldn't charge amounts to pay for the health insurance that they had to get. And that isn't true. They can charge whatever they want. They just have to show it in the price. They have to say their hamburger's $12, not $10 plus.
So a price for a good or service that does not include all mandatory fees and charges. What are examples of those?
Well, most consumers in the United States know what those are. The FTC found that 85% of Americans really feel strongly and resent those charges. And I think that's part of the context we are dealing with today in the hospitality industry. Consumers are pissed. I mean, they're angry. They aren't thinking like an owner of a restaurant or a hotel or another business. I've got to get some more fees out of this. I've got to be able to charge more, and I'm afraid to raise my prices. They're going to pay the same. It isn't going to change the price. They just want to know what it is. So that's what it's about.
So seating fees, is that?
Anything that's mandatory. Resort fees, service charges are the most common names. We had a luncheon for our group at the firm retreat out in the desert just a couple weeks ago. There was 35% of mandatory fees added to the budget for the food. And they had a menu fee, they had a service fee, they had an it doesn't matter what name you give it. If it's something that the customer is going to have to pay before they can leave and they don't have an option about it, it's a mandatory fee. So resort fees, service fees, those are the classic examples. We'll talk about some gray areas if we have time later. There are some tough issues. What about the cash versus credit if you want to charge people to pay by credit card? Does that have to be mandated? Well, I'm going to take that one on. You know, I think there's going to get to be a practical element where people say, do 95% of the people pay by credit card? And if 95% need credit card, then maybe that means it effectively is a mandatory charge. And restaurants, you know, most of them don't report a lot of cash sales. I don't know what they have on cash sales, but if 95% of your reporting for tax purposes shows it was credit card, it looks like 95% of your sales are credit card. And if you're going to charge the credit card fees, whatever they are, that the $3 that American Express or a Visa charge to the customer, which more and more restaurants are doing, then maybe that's a mandatory charge. Circumstances could make something that sounds optional be mandatory.
So you kept a placeholder at 29 capital A and now capital D. Can you tell us about that?
Yes, let's move to D. Okay, can we move one more, please?
I've lost control to move to the next slide.
Okay, can we get anyone to help us move to the next slide? I'm going to proceed. This is very detailed. And if our program administrators can help us move to the next slide there, thank you very much. You can see the fine print, and that's why I really wanted to get this slide. Thank you very much. So again, remember the setting. We have 1770 little a. Then we have 29 paragraphs. Then we have big letter A, B, C, D. We're now into big letter D, and it has two subdivisions, little Roman numeral 1 and little Roman numeral 2, or I and II that are there. This is the restaurant exception. So I'd like to start with the highlighted language in the first line, and not the first few words. It says, this paragraph does not apply to a mandatory fee or charge, blah, blah, blah. We're going to get into the blah, blah, blah. But what does that mean? This paragraph doesn't apply. It can't mean the paragraph it's in. That would be silly. What it means is paragraph 29. It is saying that paragraph 29, capital A, the prohibition of any drip fee pricing, of failing to disclose all mandatory prices in any advertisement, display, or offer, that paragraph does not apply to any, and now we're going to get into the other elements of this, mandatory fee or charge. Let's go through, I've highlighted some words to help you see where I'm focusing. For what? It's not every mandatory charge. It's only mandatory charges for individual food and beverage items that are sold directly to a customer by, and there are two by clauses. So in this slide, it just happens, one of them is right above the other one. So we're going to look at both of those clauses. The paragraph A, capital A, does not apply to a mandatory fee or charge for individual F&B items sold directly to a customer by, one, a restaurant, bar, food concession, grocery store, grocery delivery service. You can see why people call it restaurants, and particularly when you're talking about big concepts and you want to talk about the restaurant clauses, you don't want to list 10 items, but it's all those sold bys. And then in addition to that, there's or by means of a menu or contract for banquet or catering services. That fully discloses the terms of service. Boy, that last one's something that's really a big trap. We're going to come back to that. But that is the restaurant exception. When we talk about that, you have to qualify under, you have to be one of those groups of people. Some of these elements are very tricky, and let's go to the next slide and talk about some of those. Okay. We've highlighted language at the very beginning of capital D, 29, capital D, little Roman numeral 1, and at the end. It starts out, well, I should have highlighted little Roman 2, I'm sorry, subject to clause 2, little Roman 2. So what does that mean? I think it's pretty clear. It means if you're going to take advantage of this paragraph, of this exemption, you have to meet all the requirements of section Roman numeral 2. And I don't think there's any other reading, but we may get some lawsuits that challenge that. So let's go to the clause at the end. This is going to take you back to high school English. You remember diagramming sentences of modifiers and compound subjects and objects and that. What does that fully discloses the terms of service refer to? Senator Dodd had to be rushing. I'm sure they worked all night and all day, and they're calling people and trying to get them set up to get this adopted. They should have gotten one of their English teachers to help them with this. There's kind of a problem here. Most people, when Dodd talked about the victory he claimed for the restaurant industry and for the unions, he said, we've got an exemption that the food industry needs to stay alive, to be vital, while we're still providing consumers with all the information they need so they aren't misled. So everybody's going to have to fully disclose the terms of service. And as you look at that, isn't that your initial read? You say, oh, okay, that fully discloses, modifies the entire paragraph. So no matter which category up there, whether you're people selling sales by a restaurant, bar, grocer, or whatever, or by means of a menu, you have to fully disclose the terms of service. Well, that isn't a defined term. Terms of service is nowhere defined. What does that mean? Does that mean something different than mandatory fees? We don't know. There's no definition. I suppose, Mark, you're going to be very busy helping some clients figure out what that means.
We can only hope.
To fully disclose. But there's more. So there is a second interpretation of this language. And that is that the last highlighted clause, the caveat that fully discloses the terms of service, does not refer to anything other than by means of a menu or contract for banquet and catering services. That fully discloses the terms of service, that it modifies only that section. It does not modify sales by a restaurant, bar, or grocer. I mean, that's what my high school English teacher would have said, and she would have said something like, you should say, subject to clause 2 and full disclosure of all the terms of service, this paragraph does not apply. So it would be clear that that caveat applies to everything. We are seeing the plaintiffs' lawyers dragging the internet for plaintiffs to sue on junk fees. And if a restaurant thinks they do not need to disclose the terms of service clearly on their menu, you're asking for litigation. So the intent of the law before the amendment was certainly to do it. There was some intent to create some slack here, but the real issue for our clients, for the industry, is how much money do you want to spend with lawyers defending individual consumer suits that you violated the law? Those class action defenses are really messy. It costs a lot of money, and you spend a lot of time defending them. It may put some people out of business just to defend the lawsuit, even if they're right. So there's a strategy to do this. There's another problem we're going to talk about later about what full disclosure means or what needs to be disclosed.
Well, so what does that mean, clearly and conspicuously displayed? How do we do that?
Well, there are multiple levels to look at. I think we have, let's go to the next, I guess we have it later on. Okay. For now, it probably means just what it says. I believe that section D, capital D, Roman numeral 2, in clause 2 says that the mandatory fee or charge must be clearly and conspicuously. that normally means a different font, a different size, a bold type. I mean, something. It's not in the fine print at the bottom or, buried in smaller print or hidden. So it probably has that general meaning. But there is a new section that we will talk about a little later that says it's actually 770, not A, not B, but a subsection C, not in the 29s, not in the numbers, it's a 770C, that says for purposes of this act, clearly and conspicuously has the meaning, and then it refers to 1781U of the California Civil Code, which says clearly and conspicuously means set apart from and made more obvious by a different font, color, size, symbols, or whatever. But that requirement is only effective starting July 1, 2025, not 2024. And I think this is a trap.
Yep.
Roman numeral 2 says that it's a condition to the exemption at all, and it requires clearly and conspicuously display, and Section 1 requires fully disclosing the terms of service. Now, clearly and conspicuously doesn't get defined until July 1, 2025, but so what? It has a common meaning.
Right.
And this is being, I think, misquoted in the press. People are saying restaurants, grocers, food providers, do not have to comply for 1 year. They get a holiday until July 1, 2025. I don't think we read the law that way. Okay, can we go to the next slide, please? Okay, so the question is, that's it. That's the ban on drip pricing, 1770, little a, number 29, the new subdivision. A is the prohibition, capital A is the prohibition, capital D is the restaurant exemption. So what? If you violate that, sue me. Well, there's a whole group of people out there that's going to do it. And Mark, what this reminds me of, and what I fear for our clients, if you're in the hotel or restaurant business, or you're a retailer, how many lawsuits have you seen? Have you been sued or seen your neighbors for disability, website inaccessibility? They're called ADA actions, Americans with Disabilities Act actions. That's the federal law, the ADA. But various states like California have their own miniature version, uses the same words. Ours is called the Unruh Civil Rights Act, and that provides the same kind of violation that the ADA does, but it provides for attorney's fees. And there are 5 states that have provided for attorney's fees as part of the remedy. You don't just get the fix, you get your attorney's fees, which is a huge part of the cost. In fact, that's really what some plaintiffs' lawyers have made their living. They are plaintiffs' lawyers, and there are a dozen or maybe 2 that have filed something like 40,000 lawsuits over the last 10 years. There have been 40,000, more than 40,000 ADA lawsuits, either ADA and or the local state. 48% of those lawsuits are filed in this beautiful state of California. Why? Because Indiana doesn't provide attorney's fees for a violation of the law. Iowa doesn't provide attorney's fees, and people don't sue if they can't get attorney's fees, and attorneys don't go trolling for clients to sue if they aren't going to get attorney's fees. So the idea of attorney's fees and private enforcement it was government's way to save money. We won't have to hire district attorneys or attorney generals or city attorneys to go enforce these laws. We'll get people to do it, and they'll get their attorney's fees. It's an interesting idea. But if you have seen the ADA lawsuits, you think it's a plague, and it is. It's a shame. This holds the same potential because it provides for attorney's fees, punitive damages, actual damages, restitution, class actions. Those provisions already existed. They have existed in the California law and most state laws for any consumer fraud. 1770A is one of the prime pieces of the consumer law. We listed here number 1, the Consumer Legal Remedies Act. That's where a lot of these are buried in the 1780s. The unfair competition law is a separate set of laws. In the Business and Professions Code, it has a whole chapter starting at 17200, and the false advertising law, or FAL, that starts at B&P Code section 17500. So if you want to see where plaintiffs are going to be looking and what the damages come from, those are going to be the sections. We're going to hit the highlights here. This is not really a legal class in remedies for breach of law. These are not new provisions, but they tie to the so what of if you violate the law. So 1780, California Civil Code section 1780 provides the right of private action. In other words, individual consumers are authorized to sue. Without that, they wouldn't have a right to action. It would be the government that enforces the law. And the remedies are listed here for you. Actual damages, as usual. An injunction, okay. That means to stop people from behaving in the bad way. Restitution, giving the money back. Punitive damages, to make an example, and any other relief, which certainly includes attorney's fees and may include other creative remedies. So we've opened it. This is going to be the Wild West on enforcing these laws. Section 1781 of the California Civil Code authorizes class actions. Section 17, we don't have a slide for this, but Section 1783 provides a 3-year statute of limitation. And by the way, when people sue, when plaintiffs sue, they usually sue under all 3 of those consumer laws: the CLRA, the FAL, and the unfair UCL. And those laws have a 4-year statute, and the pleadings sort of mush the statute together. It obviously can be taken apart, but people sometimes regard it as a 4-year. But for violations of 1770A, it is a 3-year statute of limitation.
So when we started, you talked about also Business and Professions Code section 17568.6. Can you tell us about that?
Yes. This is Mark Berman's resort fee law, and that was the name of it originally, the resort fee law. He was outraged at a resort fee that was very high with respect to the base rate, and which was not disclosed in anything prior to his checkout. And so this is the law we have. Can we go to the next slide, please? This law is based on the FTC proposed rule that we talked about. I mean, this has the clear hand and language and approach of the FTC rule, that model that has been around for several years. This law also follows what the AHLA, American Hotel and Lodging Association, now sponsors for the last couple years. They've switched I mean, H&LA used to justify drip pricing. They used to say it's fully disclosed. It's not on page 1. We say it's a $100 room, but by page 2, you see there is a resort fee, a destination fee, a service fee, whatever it is. So before the consumer checks out, he knows everything. And they argued that for 10 years. The hotel industry was deluged in lawsuits by state attorneys general. There were, I think, 23 that banded together, changed notes, and they massively started filing lawsuits against the brands, Hilton, Hyatt, Marriott, fill in the blank, Wyndham. And they filed private lawsuits, and states began to adopt their own regulation. And I think that what happened, and the AHLA has gone from, most of those suits have been settled. They spent a lot of money on that. It's the price. And restaurants, do you want to spend money on this? Retailers, do you want to spend money? The hotel industry got the experience. They tried making the full disclosure clearly and conspicuously, but not in that first offering of price. The whole idea of the FTC is the first price you see is the total price, excluding taxes and government charges, because they want people to be able to compare. Is this a $100 room, or is it really a $150 room? And the other people who really are $125, but they charge a $25 resort fee. How do you compare apples to apples, or restaurants, or menu, or whatever? And so the AHLA switched from that resisting, as long as it's disclosed somewhere sometime before sale, to going behind one single national standard. The standard is, like 478 was, it is misleading and improper and illegal to fail to disclose mandatory fees in any display of price. So first price, the price you see is the price you get. You, I guess, could put in parentheses what the price is about, but that is the new approach. And that's what this bill reflects. This bill is law. AB 537, Berman's bill, has gone through. It applies only to hotels, motels, and other short-term lodging. So Airbnb, if you rent out your residence, it clearly, specifically applies to private residential properties if they use any kind of a platform, like the internet, the web. It also includes, let's go back just 1 minute. It also includes the websites. They are bound by this law. They are subject to this law. And attention, we're going to get there, but there's a $10,000 civil penalty per violation. Is that per day, per click, I don't know, for every violation of this law. And it's very, very black and white. Also, it couldn't be clearer who this law applies to. They say that it applies to any advertising, display, or offer. So I think that's a radio, a telephone, a window display, any kind of offer to the public in this state, in California, or to the public in another state from this state. So if you're going to have potential customers viewing your ad in the state of California, or your operations are based in California, this law applies to you. And next slide, please. And short-term lodging specifically enumerates hotels, motels, and other residential or transient lodging for 30 days or less. So it's going to get all the Airbnbs. The AHLA did not want hotels being disadvantaged to what Airbnb and the like, which have been significant competition for them. So this creates a level playing field for everybody competing for the short-term visit, the 30 days or less. And as I mentioned before, I couldn't wait, there's a specific civil penalty not exceeding $10,000 for each violation. Unlike Section 1770A, this provision appears to be enforceable only by the government. It is specifically enforceable by city attorneys, county council, county DAs, and members of the state attorney general office. So, and this is something that I think hotel industry, the lodging industry wanted too. They don't want those ADA plaintiffs' lawsuits that are driven by private lawsuits with attorney's fees. They're willing to step up to one national standard enforced by the government. We may see this tested to find out whether there's an implied right or something. There's no prohibition, but it appears to be only by the government. So that's it for California.
We have anything from the feds?
Yes, we do. Let's go to the next slide, please. As we started out, the FTC, the Federal Trade Commission, really began this grand journey into junk fees and why and how prevalent were they, are they misleading? They studied this. Their 2012 study is massive, and the research published in their proposed rule, it's interesting, the California legislation, the legislative analyst quotes giant portions of the FTC's proposed rule because of the evidence they lay out in 66 pages that are there. But this is the original father of junk fee regulation. It started only focused on hotels. They were focused, like Berman, on resort fees at hotels and motels. And from that 2012 focus, by the time it got to a proposed rule, it had expanded to any business. So the proposed rule, which some of us hoped and thought would have been in effect before California or before anything else, it started long before, still lies there. They had the last hearings on April 24 of 2024. We simply don't know where it's going to go. But look at the language. It is an unfair and deceptive practice. Now, this is under the FTC Act. Section 5 of the FTC Act prohibits unfair and deceptive practices. It is an unfair and deceptive practice and a violation of this part for any business. This looks just like the B&P code we just looked at. To offer, display, or advertise an amount, call it a price, a consumer may pay without, and the caps are in the law, without clearly and conspicuously disclosing the total price. So that's it. It's like 1770A 29 capital A. It's a ban on any display of price, offer, whatever, that doesn't show all mandatory fees. They want the total price up front.
Now, there's a HR 6543 that's pending as well. Is that right?
Yes. Let's go to the next slide. Next slide.
Too far. Oh, it's in here.
We need to go forward. I'm sorry. We're still in the FTC rules. Okay. Well, yes, there is. That's called the No Hidden Fees Act. It was introduced in Congress last year in the House. It passed by an overwhelming vote, like 370 to 10 or some number like that. And that just passed in June. So the press picked that up, that the House passed the No Hidden Fees act in June. No further action has been taken. It is, in essence, like the FTC rule that we talked to, but it is limited, like California's B&P code. It is limited to only hotels, motels, and short-term lodging, 30 days or less transient lodging. Has no impact on anyone else. And there is a Senate bill that had been around for a while before the House enacted this, that is essentially the same thing. I mean, it also is limited to hotels, motels, and short-term lodging. It similarly prohibits the advertising of any price for short-term lodging that omits all mandatory charges. So it depends on whether Congress gets tied up in the election or the Ukraine or other issues. We don't know where that's going to go.
Has the AHLA weighed in on this?
Yes. The AHLA, we have a slide that summarizes their position. And this is what I alluded to earlier. In the last couple of years, they've come around from, for 10 or 12 years, defending the disclosure ultimately somewhere on, in the process, to a single national rule, which is the rule that we're seeing in the House and Senate propositions. It is the rule that's in Berman's bill in the California Business and Professions Code, and that is kind of the model for no drip pricing. But Mark, I want to hit one point I did not have a chance to hit on Berman's bill, Business and Professions Code 17586.6. This is law. It is effective July 1. Berman's law requires two disclosures. At no time can anybody advertising a price for lodging, hotel, motel, residential, fail to disclose mandatory charges. So you can't do that at any time. But there's an additional requirement. Prior to taking a reservation, the taxes and government charges must also be disclosed. That is the only law in the country that contains that requirement. Every other proposal excludes sales tax, government taxes, government fees, but not California's law. So if you are a lodging facility, you're a hotel, motel, residential lodging, Airbnb, before you take a reservation, you must disclose the total price, including taxes and government fees.
Well, Jim, there's a lot of numbers here. Thank you for this. And I also want to thank our listeners, our audience. I want to thank my CLE for having us today. Again, my partner, Jim Butler. I'm Mark Adams, and we wish you all the best. And don't forget to contact us if you want some free swag, and we'll see you next time.
Mark, may I just say, we have the link in the materials. Go to that hotellawyer.com. That's actually a hyperlink if you get the PDF or the PowerPoint, or write that down. That is our website. It is loaded with free materials. More than 1,000 articles on the blog, organized by subject like management agreements, franchise agreements, junk fees, financing. It also has free handbooks, how to buy and sell a hotel, the guide to ADA, so many things that are there. It's a wealth of materials. Browse around and have a look on us.
Thank you.